Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on the limitation period for passing the penalty orders. The issue before Delhi ITA B bench in the present case was that for the purpose of calculating the limitation period, which date is important? First, the date on which the assessing officer records his satisfaction in the assessment order about initiating the penalty, or the date on which the Joint Commissioner of Income Tax actually issues the notice to the assessee for causing that the penalty should not be imposed on the assessee. This issue has been decided by Delhi ITA B bench in the case of JCIT versus Mohit Agarwal, and the reference number of the case is ITA/2175 Delhi/2026. The present case relates to the assessment year 21-22. In the present case, the assessment order was passed on 25th February 2023. The assessing officer initiated the penalty proceedings in the assessment order for the violation of section 269 SS, and ultimately the penalty order was passed by imposing a penalty of rupees 2,48,06,092 on 29th January 2024. The assessee challenged the penalty order on the ground of limitation before the CIT appeal, and the CIT appeal quashed the penalty proceedings on the ground that the penalty proceedings are time barred. Section 275 subsection 1 clause C talks about two dates for passing the penalty order, and out of those two dates, whichever is later, that will be the limitation period for passing the penalty order. The first date is the penalty order should be passed at the end of the financial year in which the assessment order has been passed. If we see in the present case, the assessment order has been passed in the month of February 2023. So the first time limit is 31st March 2023, up to which the penalty order should have been passed. The second time is that the penalty order can be passed within 6 months from the end of the month in which the quantum proceedings have been completed. Since the quantum proceedings, that is the assessment order, has been completed in the month of February 2023, so the limitation period becomes 31st August 2023 by taking whichever is later. But the penalty order was passed on 29th January 2024. When the penalty was deleted by learned CIT appeal, the revenue challenged the penalty order in the tribunal, and the tribunal in the present case said that the contention of the revenue that the limitation period should be calculated from the date on which the Joint Commissioner issues the notice to the assessee for imposing the penalty on the assessee is not justified, because administrative delays by the Commissioner in issuing the notices cannot extend the limitation period, and the limitation period has to be seen from the date of the assessment order. For passing this order, the tribunal relied upon the jurisdictional High Court judgments of Honorable Delhi High Court. The judgments are Principal Commissioner of Income Tax versus JKD Capital Finleys Limited. The second judgment relied on was that PCIT versus Thapar Homes Limited. The another judgment which was relied upon was that PCIT versus Rishikesh Buildcon Private Limited. Friends, this case is very important because in many cases, wherever the penalty under section 271D has been imposed on the assessee, it has been seen that those penalty orders are time barred, because the revenue has calculated the limitation period from the date when the notice was issued by the Commissioner. But according to these jurisdictional High Court judgments, and from this judgment it is very clear that the date of limitation is to be seen from the date of recording satisfaction of the assessing officer, and generally the date of satisfaction of recording satisfaction by the assessing officer is the date when the assessing officer passes the assessment order. At the end of this video, once again I am repeating the name of the case. The name of the case is JCIT versus Mohit Agarwal, and this case has been decided by Delhi ITA B bench on 16th July 2026, and the reference number of the case is ITA/2175/Delhi/2026. Thank you, friends.